Dave has had a tremendous amount of experience in the field of Indiana professional engineering licensure and ethics matters, and he's often spoken on the subject. And some of you, I hope, have been participants in some of my presentations, at least about Illinois professional engineering ethics. And so today, Dave and I are going to try to team up here and throw in a few comments about Illinois, but of course almost all of this is about Indiana. And the importance of this is that for your license renewal, Indiana requires that you have an hour regarding ethics, and so this is a very important topic. One of the things that we're going to try to cover here today as part of our learning objectives is some of these key features of ethics rules and have a sense of the purpose. One of the other things that Dave will be touching on is some actual case studies, and we don't mean hypothetical cases, we mean real instances of how the Indiana board has, shall we say, meted out discipline, and I would say with a pretty strong hand in many, many instances for engineers who have strayed from what they believe is what it should be. So we have here, just for sake of discussion, some statutory references as sources of Indiana ethics laws. And in particular, we have here on the screen before you the section from the statute that talks about the need to comply. Dave, would you like to elaborate on that, please?
Well, let me back up a little bit, Kevin, if I can. The statutes that are listed, they reflect Title 31, I should say Article 31 of Title 25. Title 25 deals with a number of occupations and professions that are regulated by the state of Indiana. Article 31 deals specifically with professional engineers. There are earlier sections in Title 25 that are kind of uniform rules and regulations that govern a number of occupations and professions, professional engineers included. So I don't want the listeners here to think that the reference to Title or Article 31 is the only one that deals with professional engineers. There are other portions of the Indiana statutes that very well apply.
So one of the things, though, that we're going to concentrate on here a great deal today is Rule 11 of Title 864. Now, as part of your handouts, you should have a copy of Rule 11, and what I did is I copied and pasted it off the website. It's approximately 2.5 pages. And when we talk today about Section 4, Section 7, and so forth, you'll see it's right there in front of you, and because of that, we're not going to be reading these various sections, of course. We'll be calling on you to read those now, and hopefully again later on, if you haven't already done so, just to get a flavor for how these rules look. One of the things that I always remind people, too, is although we can certainly talk about Rule 11 as a source of Indiana professional engineers' ethics, one of the things that I would urge everybody to keep in mind, too, is your own common sense. So often, people sometimes find themselves wanting to rationalize their conduct or think that they can kind of, trot by or sneak by or whistle past the graveyard in terms of the fine readings they might wish to give of something they find in Rule 11. Well, I would say that is courting disaster. Dave, what do you think?
Well, I agree. Given the strict interpretation that the Indiana Board for Professional Engineers gives to these rules and regulations, it's not smart in Indiana to play fast and loose with these rules.
So one of the things then that we want to urge people to have in mind here is just how does the PE board work? What do they do? And we point out, of course, that they can have that they can take disciplinary actions beyond just ethics. And as we point out, for example, a failure to file tax returns would be an example. An engineer participating in a scheme that involved murder, for example. Well, that's just too easy, perhaps. But the point is, today we're going to focus more on what truly is engineering conduct as opposed to what any member of the public might do that would violate the law. So when we think about analyzing ethics questions, one of the things that some people find troubling is how broadly stated some of these sections of the rules can be. And Dave came up with some case studies that we're going to be talking about. And Dave, one of the observations I made was that sometimes the board would use a very broadly stated section of the rule and apply it to a relatively narrow circumstance. For example, Section 4 talks about the engineer recognizing the primary obligation to protect the safety, health, and welfare of the public, and yet, lo and behold, we find out that they're suddenly taking that, what I would say is a somewhat broad statement, and applying it in a very specific instance.
Very true. There are a couple cases that I'd like to present, and I suppose this is an opportune time to do it with regard to Section 4. Let me give you the facts. An Indiana engineer was disciplined on the following facts. On an occasional basis, the engineer would be out of town on business. A non-licensed employee would sign and use the engineer's seal on various plans, drawings, or specifications. These materials were not final reviewed by the engineer, and they were then submitted to the clients without a final review. The board found in mitigation that the materials were always reviewed at a later date by the engineer, and that no changes were ever required, and the associate subsequently did obtain his PE certification. However, the board found a violation of Section 4, finding that the public safety, health, and welfare had in fact been jeopardized. The board also found a violation of Section 7 concerning the unauthorized use of the engineer's seal. The sanction was an indefinite suspension, and the engineer could not petition for reinstatement for at least 30 days. And that is known as the State versus Kimbley case.
So let's think about that a minute. So the engineer was suspended indefinitely. That means that until he would petition to be reinstated, he could not practice professional engineering. And they basically said, too, don't even bother to come back for
30 days.
For at least 30 days. Now, perhaps, of course, they would gladly have entertained a petition, not gladly, but they would have entertained a petition, 45 days or something. But the point is, they could have said, okay, you're suspended 30 days, and on the 31st day, you're automatically reinstated. Not so.
No.
Not so.
No, and suspension could be considerably longer if the engineer did not get around to formally petitioning the board for reinstatement.
Which makes for a pretty tough situation all the way around. But, you know, with the point that we have up on the screen, and we'll come back to Section 4 in a minute, the one thing you want to keep in mind if you're talking with a colleague or facing an ethical question, make sure that the facts are correctly before you. In other words, sometimes these questions can turn on relatively small facts, dates, that sort of thing, and if you're being asked to give perhaps a off-the-cuff opinion or something, be careful about shooting your mouth off until you learn what all these facts are, because it might make a difference. Now, one of the ways we've approached this is to talk about the Rule 11 sections pretty much in the order in which they appear. We're going to cover these somewhat quickly and get on to Section 4, which we think, and Dave has another case study, I believe, for us on that one. But one of the things to bear in mind is with Section 2, you see that you're going to certify that you've read and you agree to abide by the statutes, the act governing professional engineers. There's no ignorance as an excuse approach here. No way, no how. The other thing that they want to point out, too, is that engineering is a privilege as opposed to a right. And I mean, what more can be said about that? Sometimes people think that it's a right, and it's true that they're entitled to due process guarantees if the state wants to take away that registration. And there is a somewhat elaborate procedural safeguard there, including the right to have counsel be present, and we're going to touch on that. But nonetheless, you must realize it's the privilege. So going back to Section 4, one of the points that we've already made about the primary, it is the primary obligation, but an area where there's often question is when the PE's professional judgment might be overruled. And what happens then? What does the PE do?
Well, the PE is going to have to seek a source and authority, shall I say, for some guidance on that, because if he feels that the engineering judgment that's being exercised by someone else endangers the public health or safety, he needs to make either the owner aware or perhaps the municipality, if it's a government job. He's got to, I don't want to say whistleblow, but he's got to report what his beliefs are that the public health and safety is being compromised or jeopardized.
And I would urge that it's the individual PE's professional judgment. This is not a vote of all the PEs on the job site or a vote of all the PEs within the office or something like that. For example, if you're the PE who is the engineer of record and you have questions, it's time to stop and take the action as opposed to laying back and figuring that somebody else will deal with it, or, well, that just doesn't apply to me kind of a thing.
So let me talk about another case, Kevin, that I think maybe illustrates a bit more about Section 4. Engineer A designed and prepared drawings for a building in a corporate park in Fort Wayne, Indiana. Approximately a year and a half later, a second building, similar to the first, was to be added to the office park. Several months later, the respondent engineers submitted drawings for the second building and filed an application for construction design release to the Indiana Department of Fire and Building Services. The respondent engineer certified that the plans and specifications to be filed in conjunction with the application were created by me and or my employees. In reality, some of the drawings were identical reproductions and some were reproductions with minor modification of engineer A's work on the first building. Prior to the submission of the drawings to the state, the title block of respondent engineer's firm was substituted on the drawings for the title block of engineer A's firm. In addition, the building design plans required substantiation of soil conditions for purposes of proper foundation design. Since the second building was to be erected on a different location near some questionable soil conditions, the respondent engineer recognized the need for additional soil borings and requested they be made. The developer submitted a letter to the respondent engineer indicating that the original soil information was satisfactory and that they would accept responsibility for the foundation design. On the basis of this letter, the respondent engineer then submitted the original foundation design without further testing or design. The board found that the engineer had violated several sections of the state statute as well as sections 4 and 7 of Rule 11. The board found these to be serious violations and suspended the engineer indefinitely and for not less than 2 years, to be followed by 2 years of probation if reinstatement was warranted. That's the matter of State versus Nord. So it did not end well for the engineer in that case. What concerns me, Kevin, is they gave at some length, they talked about the soil conditions, but they did not discuss it, and it didn't enter into their decision in terms of discipline. And I'd really like to know, I mean, I think this goes to the public safety and welfare. What do you think?
I agree, absolutely. And of course, too, you know, anytime one engineer is seemingly stealing the work of another, that obviously looks very bad. Yes. And it looks as though somebody is just trying to make a fast buck by taking the work of the first engineer, Engineer A, and reusing it, and reusing it without, seemingly at least, doing any particular analysis to verify that what Engineer A did on the other building was absolutely a correct application for this second one.
Right.
And the fact that someone says, well, don't worry, we'll take responsibility, or we'll hold you harmless, or whatever, oh, I can't see that, because the engineer has to stand on his or her own personal and professional judgment, and not just lay it off, as it were.
You know, going back on this soil issue, though, I mean, you've got a developer who quite probably is not a professional engineer and doesn't have any training as to good soil conditions, and yet the engineer is taking direction and orders, if you will, from the developer. And I think here we go right back into Section 4. What should the engineer have done, perhaps, to mitigate these charges? Should he have gone to the municipality in the case, or if the developer was not the owner, should he have gone to the owner?
Yeah, maybe so. I mean, and why not go back to the first engineer and attempt to work something out there too? Obviously, they didn't want to share a fee, it would seem. So it would seem.
Right.
Well, one thing I would point out also about many of these ethical rules and the way they're handled by the state is the matter about hindsight, especially when there is a dangerous result that happens. With hindsight, if someone loses a life, they're going to come back and they're going to want to scrutinize and see what could have been, should have been done differently and better. This matter that Dave just talked about, that case study, arguably it was the first engineer who may have been injured. It's not as though the building collapsed because the soil analysis was done poorly, so it seems. But nonetheless, when and if there is a problem, the collapse of a grandstand, the collapse of the temporary shoring system, so forth and so on, well, rest assured that that's where they're really going to be involved, especially when members of the public, as opposed to just a developer, are involved. Okay, so we have a couple more here we're going to cover here somewhat quickly, and number 7 is one that requires a particular talk. But on Section 5, one of the things they're pointing out is practice only in the specific technical field of engineering for which you're qualified. If your forte is electrical engineering, just because you have a PE seal, to state the obvious, that doesn't mean that you should suddenly be sealing HVAC drawings, much less structural or other matters, and it just doesn't follow that you can do so. Even if you're the overall engineer of record for the project, you're still only to be practicing in the specific area for which you're qualified. Now that kind of dovetails with number 6 a little bit, though, that you can accept an assignment, but you have to be associated then with qualified associates, consultants, or employees. I would suggest that, although I don't know that you've seen case studies on this, Dave, nonetheless, I can picture the board being very careful about how they might scrutinize an engineer's conduct here.
I agree with that, Kevin. They would scrutinize it.
That brings us to number 7 about sealing documents, plans and documents. Dave, do you have another case study for us on that one?
Yeah, there's a couple of them, Kevin, actually. In addition to the Kimbley and the Nord cases that I just talked about, there are several cases concerning the unauthorized use of an engineer's seal. The first matter arose out of a report generated by the Indiana State Division of Consumer Protection, and it was sent to the Attorney General's office. The respondent engineer owned his own engineering firm. Occasionally, he would provide professional engineering services to a separate and independent engineering firm on an independent contractor basis. The engineer was the sole owner of his own corporation, was not a full-time employee of the other firm, which was known as Pace Engineering. During the time that the engineer was an independent contractor for Pace, He would place his seal and signature on PACE plans, design sheets, specifications, reports, studies, and other engineering documents. He never placed his seal and signature on the title pages or used the title block of his own company on any of the documents. Therefore, the impression given was that the respondent engineer was an employee of PACE. The board found that by failing to properly place his seal and clearly identify his association with PACE, he violated several Indiana statutes and rules and has allowed and assisted PACE to advertise in a false and misleading manner. There was a stipulated resolution which included that the engineer's license was placed on indefinite probation for a period of not less than 6 months with the following conditions. He was to submit to the board a complete list every 3 months of all projects for which he placed his engineering seal, and he was to prepare a paper to all professional engineers in the state of Indiana explaining the requirements and procedures for work that was prepared by a professional engineer acting as an independent contractor for another business. And he also received a letter of reprimand. That is the State versus Lewis case.
It almost sounds like a grade school homework assignment. Do a paper for everybody in the class that explains why you shouldn't chew gum during class. And yet, on the other hand, easy for us to chuckle as we sit here right now. I'm sure that engineer was sweating bullets about what the board was going to do.
Yeah, and you know, this exercise of the written report forced that professional engineer to sit down, look at the statutes, and look at the rules, and interpret them in a fashion that would be instructive for other professional engineers. There is another Section 7 case in which the engineer sealed with his seal a document entitled a land survey for a local conservancy district. The engineer was not and had never been licensed as a land surveyor in Indiana. In his defense, the engineer had recommended to the owner the use of a registered land surveyor, and in fact a registered land surveyor was engaged for the work. The land surveyor's work was incorporated within the engineering drawings, but the land surveyor's seal was inadvertently not applied to the land survey included within the drawing set provided to the owner. Respondent claims that it was simply an inadvertent clerical error. The State Board viewed the charges a bit differently, as the respondent engineer was issued a letter of reprimand and a $500 civil penalty was imposed. That case is State versus Curry.
You know, I think that represents almost the low watermark of discipline that we've seen. Only a letter of reprimand, only a $500 fine. You know, this is a good point maybe just to bring up too, that I can't speak for all states on this, but in many instances, it's, first of all, I think in probably every state nowadays with the internet being so popular, it's quite easy to see whether or not so-and-so is in fact truly a registered professional engineer in Indiana or a licensed PE in Illinois. But here's my point about that. In many states, they will also indicate whether or not the registrant has ever been disciplined. And so, for example, for Illinois attorneys, just as an example, if I were ever to be disciplined, that stays with me the rest of my career. And it's a terrible stain on one's professional status to have that go through. Dave, what do you think about that?
Well, in Indiana, I mean, clearly these cases that I'm talking about, and these are just a few of quite a number more. I mean, these are accessible on the professional engineering website through the Indiana government. So these are not secret proceedings. I mean, these
no, not at all.
These are out there for instructional purposes. Now, the board has the ability to do private reprimands, which are not a matter of public record. But it's fair to say that other than private reprimands, things are going to be a public record in Indiana.
A couple other things quickly in that same vein, and then we'll move on. So if you apply to become a professional engineer in some other state, Nevada, Iowa, and so forth and so on, don't be surprised to be asked if you've been disciplined anywhere else. And of course, that's going to carry forward with you. Maybe you have a municipal job somewhere and they want to know if anyone in the firm has ever been disciplined or scrutinized or whatever. So best to be squeaky clean at all times than to try to dig out of a hole later.
And also, as one of the cases that hopefully we'll get to in a bit, you better not fib on any application about your past. Clearly, on the Indiana side, their application does provide and require you to tell about any past discipline.
So here's a question, for example. Let's say that you're the only person in your office of many engineers that has the Indiana registration. And your firm is based in Illinois geographically, and there's a fair number of Illinois PEs or Illinois SEs in your office. And they come to you and say, well, Joe, we need you to seal these drawings because you're our Indiana guy. Joe looks at the drawings and says, gee whiz, I'm not a structural engineer. That's outside of my field of competence. And the boss leans on Joe a little bit and says, well, Joe, but you're my Indiana guy. What should Joe do?
He'd be well advised not to use his seal on those drawings.
I would agree with that. He's running a risk. Oh, he may say, I had a course on that in engineering school. Okay, I just hope for his sake if he seals those drawings, he's prepared to demonstrate that he in fact actually had that competence.
Again, these are fact-sensitive inquiries, and he's going to have to be prepared, if challenged, to show exactly he knew something about structural engineering.
All right, let's move on then to our next one here about being objective and truthful in all professional reports, statements, and testimony. The problem we often see here is that if you're asked by a lawyer to serve as a consultant and then possibly being an actual expert, you know, lawyers, I guess just because of the nature of the adversarial process, they're always looking for a little bit of an edge with their opponents. And how far can they push the matter? And is the engineer going to be an extension of advocacy, or is the engineer going to be someone who truly can be relied on by the judge and by the jury? That is part of the question. So, for example, we point out to you Section 10 that says that if you're going to be testifying or expressing an opinion in that sense, there are three things that we have quoted there that you can see on the slide about what's going on. And technical competence, that would seem to be a given, that you have to have adequate knowledge. You have to do your homework, in other words, as opposed to, sure, just throw me the hypothetical, I'll give you an answer. And honest conviction of accuracy and propriety.
I would add to that, in Indiana, there is case law that says if an expert does have the technical background and skill, he can be an expert in the state of Indiana, even though he is not licensed as a PE in Indiana.
Well, that's right. We had a case in Illinois that got into that where a professional engineer licensed only in the District of Columbia was going to testify in an Illinois court. One of the things that the courts made clear is that the courts will figure out who can testify as a witness. That's not to say, though, that the PE still couldn't face discipline. Now, in that instance, it happened to be Illinois, but for our sake, it could be Indiana, too, if the expert, shall we say, stretched, with that euphemism, stretched his ability about knowledge and experience and competency and all that whole stuff. What we're trying to say is you might just get, the expert might be permitted to testify as far as the judge goes, but that may very well not be a defense or a bar from professional licensure or professional registration prosecution by the board that thinks that you just went too far when you offered those opinions?
Actually, very sensitive, Kevin. I would say, though, that I believe the Indiana board would give deference to a trial judge in granting the ability for the expert to testify.
One of the things, I don't know the answer about Indiana, but one of the things that I'm seeing more and still more is that state licensing boards, we're not talking about the courts now, we're talking about state licensing boards, are viewing more and still more the providing of expert analysis, the providing of expert testimony as coming within the practice of engineering. So let me give you an example. Say 20 years ago, for example, I had a case that involved, there was a project that happened to be in Grand Rapids, Michigan. But the point I'm making is that some Illinois PEs were called upon to look into the adequacy of the concrete tank and otherwise render various expert opinions. And the question arose whether or not they had to be licensed in Michigan to testify in a court in Michigan. And what I'm getting at is more and still more are of the state bodies are saying, well, regardless of what the court says, we're saying that we don't want these out-of-state engineers coming in who are not licensed in our state and purporting to analyze or otherwise offer opinions about structures, projects, anything to be built in our state without being licensed here. So if your client's lawyer is coming to you with suggestions or tips on what not to include in your report or what your opinions ought to be, our strong advice to you is don't waver from your own ethical obligations. Dave, tell me what lawyer would ever ask an engineer to bend his opinion? Who would do that?
I don't know. I can think of a few.
Yeah, just a few. That's right. Just a few. Oh, come on, can't you say this or that? Right. And that's where hopefully you maintain your own backbone and do only that which you're, in fact, actually comfortable with. Now, on the other hand, somebody might say, well, wait a minute, though. A lot of these cases involve battles of the experts. And the people in state government, whether it be the courts or whether it be the disciplinary bodies, appreciate that experienced experts in good faith with honest conviction can, in fact, have opposite opinions. Nothing wrong with that. And just because one side wins and the other one loses doesn't mean that the expert is somehow guilty of malpractice, much less a violation of ethics or that sort of a thing. But our point, though, is if you feel that you're working on your own honest convictions, a matter within your own competency, and you've done your homework, you have nothing to be concerned about going forward from there, including common law damages.
And you know, that's at the heart of the adversarial system. I mean, the other side has the ability to poke holes in your opinions.
Dave, why don't you do this one about Section 11, Rule 11, public speech.
Well, there is a slide here, and Section 11 speaks to engineering matters of public policy. In doing so, if a professional engineer is asked to render some statement, he or she must identify himself or herself and disclose the identity of any interested parties, and also reveal any financial or pecuniary interest that is being received for rendering this public statement.
So I've given a little hypothetical here about Ajax Windmills wants Sue Sign PE to be interviewed by the press. And of course, Ajax would love to have a professional engineer be able to say why the windmills ought to be allowed in Lake Michigan or somewhere else in Indiana. And maybe she thinks it is actually a good idea, but can she just step forward and be some, shall we say, member of the public, almost as if they had grabbed her as she was walking down the street and say, Sue, you're a professional engineer. What do you think about this? As if it were all just so much innocence. So, Dave, what should she say? What would she need to do?
Well, she's going to have to, again, in looking at Section 11, if she is in fact being compensated, she's going to have to disclose by whom she is being compensated, and reveal the existence of that financial interest. But to come across as if this is her opinion when she's obviously got a point of view that's being paid for is not ethically correct.
Even if she might say that her opinion would be the same whether she was being paid or not paid.
That's correct.
It's this idea about the sort of an appearance of impropriety concept that's going on. Let's move on to our next one here, number 12, about conscientiously avoiding conflicts of interest. But when unavoidable, disclose those. Now, here's one point I'd like to make, and I found this from experience over the years. Lawyers have a harsher conflict of interest situation than engineers do. I'm not saying that engineers don't have a strong one, but just take it from me, the lawyers have an even harsher one. So why do I bring that up? The point I'm making is that if your conduct about a conflict of interest is being judged by a lawyer, inevitably, so it's been my experience, they, like without even thinking about it, sort of transfer or overlay legal ethics on engineers. Obviously, highly unfair and improper. My point, though, is be aware of that. If you were, called upon in the city council to explain your actions, and the city attorney is there, and maybe she wants to think that your standards are the same as her own. Not so. That said, though, of course, you still want to be very careful, and the conscientiously avoiding is really important. And that takes us to Section 13, about avoiding all known conflicts of interest, and then promptly informing the clients when your judgment or quality of services might be influenced.
And Kevin, I'd like to talk about a case here in which the respondent engineer was an officer and employee of an entity known as Triad. Triad contracted with the municipality to provide on-call engineering services. Subsequently, and at the request of the mayor of the municipality, the respondent engineer personally provided acting city engineer services during a period when the municipality was without a regularly appointed city engineer. And these services averaged around 5 hours per week. The engineer was never formally appointed city engineer, although he had been introduced before several board meetings as such. And during this time, Triad continued to provide services to the municipality. The engineer was also a 24% owner of a second company named PMI, which had been established as a WBE. PMI and Triad worked in conjunction to provide services to the municipality. Thereafter, the respondent engineer pled guilty and was convicted of the offense of conflict of interest under the Indiana criminal statutes for knowingly or intentionally having a pecuniary interest in a contract or purchase connected with the governmental entity he served, and that such pecuniary interest was not disclosed to his employer. Based on the conviction, a complaint was filed with the Board of Professional Engineers. In addition to the criminal sanctions that were imposed against the engineer, the board issued a letter of reprimand with respect to sections 12 and 13, and the letter of reprimand was placed in his file. He, in addition, was required to prepare a treatise relating to conflicts of interest to be submitted for publication in various professional engineering media. This is a case of State versus Frizzell. And reading between the lines, I've got to believe that I just question how serious this conflict was. because I think the board took into account the criminal sanctions that he faced, and I would have expected in this case a more severe penalty from the board.
I agree. I agree. And if you've learned anything here today, one thing is that the board is not hesitant to impose what strikes me, at least, as being somewhat stiff penalties here. Let's move on to Section 14. But before we do that, I'll just call out, you know, you're better off erring on the side of informing too much too soon and doing it in writing and memorializing that there's been consent given. This is very important to be able to prove it later on, especially if the people you're dealing with maybe, well, might strike you as being a little slippery. So undivided loyalty. Here, don't accept compensation from more than one party unless full disclosure and agreement. One example I've seen here that comes up is the engineer of record is asked to prepare shop drawings for the subcontractor, and so the engineer finds herself in a situation where she's accepted compensation from the owner as the engineer of record, and because the contractor, for whatever reason, didn't have an engineer, didn't want to have one, felt that the engineer of record could do it cheaper, because after all, she already knows the project. You know, gee, can't that person do it? Well, our point is, I suppose that can be done, but there has to be full disclosure and agreement of all parties. Full disclosure. So, and again, I urge that it be documented. Let's move on to Section 15.
Let me stop you there. There is a reported case on Section 14. In that case, the engineer submitted a proposal on behalf of a firm known as Major Engineering as its director of engineering, and it concerned a road construction project. The engineer then submitted a proposal on behalf of his own company, which was known as Dells, for the same project. His employer, Major, determined that the engineer was using time and resources that were being billed to Major for promoting and soliciting work for Dells, and he was terminated from his employment at Major on the same day. That same day, the respondent engineer contacted an employee of Major and requested that the employee download all of the engineer's proposals for Major and Dells and then delete the files.
It just reeks of impropriety.
Correct. Major seized the engineer's company computer and found various documents, files, emails, etc. that proved the conflict of interest allegation to be true. On the Dells proposal, the engineer did not replace the name Major Engineering with Dells' name. It is believed that the engineer created the Dells proposal after he created the Major proposal. And various emails prove that the respondent engineer was using Major's resources and time to promote and solicit work on behalf of Dells. The board alleged that the respondent engineer's conduct constituted a violation of statute in that he continued to practice although he became unfit to practice due to professional incompetence by violating Section 14 when he received compensation from both Major and Dells for creating the duplicate proposals for work. Subsequently, there was a voluntary dismissal of the complaint with the suggestion that portions of the original complaint that the Attorney General's office drafted were factually inaccurate. We don't know where those inaccuracies were, but the motion for the voluntary dismissal stated that the board provided the respondent engineer with instructional advice on how to better write proposals to clearly establish professional associations, as well as other instruction about professional best practices in the respective areas of engineering. That's the State versus Durham case, but you know, the point of that is this is a reported case. I mean, it's on the records, and it's somewhat of a blemish because you don't know how he was exonerated in the final analysis. All we see is the bad facts.
Absolutely, absolutely. Let's go on to number 15 about gratuities. You know, what strikes me about this is that it doesn't put any materiality or any quantitative notion about gratuities. You know, it doesn't say like up to $25, up to $100 or something like that. And the question that arises is, gee whiz, I mean, so is that to say that the PE can't accept anything? Like what about social friends even, for example? Dave, what would you think about that? What if people have been social friends for years because, you know, like there's a contractor and there's a PE and they've known each other for years and years. Can the PE ever even, like, go to, you know, if he's at a bar and the guy says, let me buy you a beer?
Well, Kevin, you know, I've had some experience in this and have done some research on it, and there is kind of a bright line test, and that is the last time I checked, $50 was the magic number.
Okay.
And if it was, you know, wants to buy you dinner and it's under $50, you're probably okay. But if you want to go to a hockey game, let's say you want to go to the Blackhawks game, well, we know the face value of those tickets is well in excess of $50. You're flirting with trouble there.
Absolutely. I couldn't agree more. Be careful and be prepared. You know, I mean, what you're getting into is a facts and circumstances situation if you accept it. And, well, you just don't know whether or not the board will see it the way you do. Let's move on as we get a little closer to the end of our hour. No kickbacks. Well, okay, that seems pretty obvious. The question is what the so-called kickback looks like as opposed to whether or not it's an obvious one. I mean, the obvious ones are just too easy, but that's the problem to deal with. Let's talk about the public body situation. We're kind of lumping together several of these. And Dave has another case study for us on this.
On Section 18, the engineer was at all times the president and the sole stockholder of his firm. He hired an employee by the name of Mathers in his engineering firm, and Mathers was one of 3 county commissioners on the Orange County Board of Commissioners. During Mathers' employment, respondent signed an agreement with Orange County whereby his firm would be responsible for the inspection and reinspection of all county bridges and to compile its findings in a report book. Respondent was charged of failing to keep abreast of current standards of professional theory or practice by violating Section 18 by accepting an engineering contract from Orange County when one of his employees was a commissioner on the Orange County board that actually awarded the contract. The respondent engineer was issued a letter of reprimand and assessed a fine, but during the proceedings, the engineer retired. And that is State versus Jones. It's obviously not a good way to go out in your career.
No, absolutely not. I would point out also that this Section 18 is a little stronger than the Illinois language, for what that's worth. But I think 18 is really what Illinois ought to be, without any doubt.
Kevin, let me talk briefly about Section 19, which talks about political contributions. And I frankly am surprised that there are no cases on this section, because this is a recurring issue, ethical issue for engineers. I mean, I had one head of an engineering firm. He came to me and he said, Dave, he said, we do about 60% of our work for a good-sized municipality. And he said, when those political tickets come, and they could be $100 or $500 or $1,000, he said, what am I supposed to do?
Really a tough question on that.
It's a tremendously tough question. Now, you say, is there any way around it? I said, well, do you have a written ongoing contract? He said, yeah. I said, I would say to you that if you were bidding on work, as long as there were no understandings before the submission of the bid, after the fact, you could make a political contribution. Another point is, I asked the head of this engineering firm, I said, how do you make the contributions for these tickets? And he said, well, the firm writes a check. I said, no. I said, if you're going to continue to do this, I said, you have your professional engineers write personal checks for those tickets. I said that will tend to mitigate the ethical problems that I think you've got under Section 19.
Well, that's right. What do you think about this crazy idea? And that is they write checks to both candidates. For example, that's hedging one's bets.
What you're doing, Kevin.
But, you know, and I don't know. I mean, I think Section 19 is a real tough one.
It's one of the toughest ones.
And so the engineer might say, well, I've got it figured out. I'll have my spouse do it. I'll have my son or daughter do it. Right. I don't know. I mean, maybe that's technically good, but I don't know that it can really withstand scrutiny if it gets to that.
Right.
Okay, let's press on to numbers 20 and 21. Here we have the situation where you can't overstate your qualifications and competence. And lawyers and courts refer to quote-unquote puffing as what might be thought of as sort of like putting yourself in your best light. But you can't say that you've designed 6 bridges when you've only done 3. Whereas if you offer, shall we say, opinions that say that I'm actually quite familiar with the issue of the, the electrical code, and I've designed many high school buildings for which I've done the HVAC and electrical and plumbing, and I consider myself quite competent. You know, those are more personal opinions, I suppose. But again, I see this as a hindsight problem. In other words, something goes wrong at the project, and now they're saying, well, how was it that Tom could say that he had experience in that field when it doesn't seem that he did? That's the problem. We could talk about any of these for almost a half an hour or an hour, and we're just going to kind of keep going through here, especially as we get near the end. 22, you know, I almost think in a way, Dave, why don't we just kind of maybe summarize any of these that we think 22 through 25 might have some.
Yeah, 22 is, there is a case on that. It's the State versus Kenny case, and it's a pretty straightforward case. I mean, the engineer was indicted in federal district court for fraudulent billing practices, and he was found guilty, and of course the board got wind of it and found him to be in violation of Section 22. The case didn't tell us what the criminal sanction was, but on the state side, he lost his license for at least a year, and you know, he had a petition to get back.
And on Section 23, if someone else had learned about the PE making a violation, then she would have to report that in their own right and cooperate as needed to let the board uncover the facts.
And I think really if, you don't have to editorialize if you're going to make some allegation or relate some factual matter. I think that's all you have to do. I don't think you have to embellish it at all.
No, in fact, I would urge not.
Correct.
I would present the facts and let the board make its own conclusion. I saw this. I have these papers. Let them form the conclusions about what it means or how it adds up, shall we say. As we near the end here, Section 24, conviction of a crime, well, that's hardly a surprise. They limit it to a direct bearing on serving the public, but frankly, Dave, when I read these case studies that you told us about, the board seems to have some ingenuity about how something the PE does can have a direct bearing.
Yeah, sometimes they are a bit of a stretch. I mean, there are 2 cases reported under Section 24. One's the Phillips case is a no-brainer. I mean, the guy conspired to blow up a restaurant and was found guilty in federal district court for explosive devices. So, needless to say, he had an indefinite suspension of his license. The other one is a bit more vexing, and it was a registration case. the engineer, in his application to renew his registration, completed, and it was an online license renewal. Question 3 of the application asks, since you last renewed, have you been convicted of or pled guilty to a violation of a federal or state law or criminal charges pending? He responded in the negative. Well, 7 months earlier, he had been found guilty of operating while intoxicated, and the board obviously got wind of it, and they placed his engineering license on indefinite suspension for a minimum of 2 years and ordered a civil penalty of $1,000 along with the cost of the proceeding, which I'm sure was substantially more than $1,000. And that's the registration case of Gorman. That one's kind of scary, but I mean, I doubt that he would have gotten the sanction that he did if he reported the OWI, but he lied about it.
Oh yeah, that's President Nixon learned that a long time ago. And one thing to bear in mind too is reciprocity, Section 25. If your license is suspended in one state, you can assure yourself it's sort of a domino situation going forward from there.
You know, and there is one reported case on that, and it involved a professional engineer who had licenses in Illinois, Wisconsin, and Indiana. He was disciplined in Wisconsin basically because a building that he designed collapsed, causing the death of an employee and over $100 million in damages. Once that hit Indiana, they permanently revoked his license. Not surprising. That's the case of State versus Chief.
So one of our last substantive slides is this: how do you resolve an ethics question? And it's always a good idea to seek some advice and maybe talk it over in a hypothetical fashion. But bear in mind, though, that if you reveal all of the facts to another PE, that PE might have to report under Section 23. Dave and I, being lawyers, yes, we are quick to say that when you do get advice from your lawyer, it should and will remain confidential. So, yes, that's what lawyers are about. Get the confidential advice that you need. One of the things that Dave and I talked about, too, is we couldn't imagine, as we were looking through these case studies that Dave unearthed, couldn't imagine an engineer facing potential suspension of a license for years, certainly months, without having legal representation to guide that engineer through the facts and the law.
Yeah, that's definitely true in Indiana. You'd be well served on that. I don't want to sound like a commercial, but you'd be well advised to have counsel.
We're pretty much at the end. You know, Dave mentioned about Wisconsin, and let me just give a plug for ISPE about how they're going to be having a presentation for those who are licensed or registered in Wisconsin as a professional engineer, and that'll be in July of this year. If you're interested, well, please let Courtney know, and stay tuned for your ISPE Weekly Illinois Engineer This Week to provide you information about that going forward. Lastly then, Dave and I provide our CVs here at the end. I will tell you that Dave and I do stand ready and would be pleased to answer any questions you might have about this. One last point I'll make before I turn it back to Dave is when faced with an issue like this, look at your professional liability insurance policy. Nowadays, a lot of the policies are providing a fixed sum of money, maybe $5,000, maybe $10,000, for you to hire a lawyer or otherwise be represented in a disciplinary matter. They don't consider it a professional error in the true sense of your professional liability policy. It's got its own little coverage there on the side. But take a look at that, because you might just be able to find yourself a little pot of money to hire a lawyer who can deal with this on your behalf, because I just cannot recommend that any engineer would want to represent herself in Indiana, Illinois, or any other state of the union when faced with a disciplinary issue. Dave, why don't you give some closing comments, and we'll...
Really, Kevin, I think you've covered about everything, and I know we're probably past our time. I would say that there are, as part of your, I'll call it a handout, there are quiz questions that I think you need to, each of you need to answer and submit back to Courtney in order to have your time here certified to the state of Indiana.
Well, I agree, Dave. Courtney, let us hand it back to you. Are you able to hear us from here?
Yes, I am. And also, I just wanted to reiterate, there was a link to a quiz in the email that you received where you connected to this webinar. And it will direct you to an online quiz, and completion and passing of that. After completion and passing of that quiz, I will send you a certificate, a PDH certificate for today's webinar. Just a reminder that those quizzes should be completed by close of business on Friday, and I will do everything in my power to then turn those around and get those to you mid-next week. If you have any questions, please feel free to email me. Everyone on the call should have my email, which is courtneyadams@illinoisengineer.com.
Well, thank you, everybody, for listening to us so patiently here today. And like I say, Dave and I stand ready when and if you should have any questions in the future in this very important subject.
Practice ethically.
Yes, thank you again. Courtney, it's all yours.
Okay, thanks everyone, and have a great day. If there's any follow-up questions, you can direct those to me as well. Have a great day.